Hi, my name's Emma.
Hi, my name's Brandon.
And my name's Aiden, and we have
At
Wisconsin versus Yoder.
Hey, Aiden, what's the story behind this case?
That's a great question, Britton. This case, taking place in 1972, is about an Amish family known as the Yoders. So the First Amendment protects the rights of people to exercise their religion freely, and the government cannot infringe on these beliefs. So the Amish commonly believe in stopping school around the age of 14 or after 8th grade. But unfortunately, the state of Wisconsin requires students to attend school until the age of 16. And Amish communities seek to become self-sufficient, so in order to prepare them for their adult lives and roles in their community, the Amish provide their children with their own form of schooling after 14. The state of Wisconsin convicted Mr. Yoder and two other parents because his daughter, Frida Yoder, and the two other parents and two other children stopped attending school after 8th grade. These parents were required to pay a $5 fine, but they refused, and the Yoders appealed to the Wisconsin Supreme Court, saying that their First Amendment had been infringed upon. The Supreme Court ruled with the...
What was the constitutional issue involved in this case?
Well, you see, the issue, as stated by street law, is as follows. Under what conditions does the state's interest in promoting compulsory education override parents' First Amendment right to free exercise of religion? So the First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and the 14th Amendment states, nor shall any state deprive any person of life, liberty, or property without due process of law. So this essentially means that no laws can be put in place that prohibit a person from practicing their religion because it would be taking away one of their...
What was the ruling of the case?
Yoder legal case in which the U.S. Supreme Court on May 15, 1972 ruled 7-0 that Wisconsin compulsory school attendance law was unconstitutional as applied to the Amish. Permanent members of the Old Order Amish Mennonite Church because it violated their First Amendment right to free exercise of religion. The ruling in Wisconsin versus Yoder developed the precedent that parents were allowed to educate their children outside of either the public school system or traditional private schools. In doing so, it prioritized the free exercise of religion over state interests.
Were there any dissents in the case?
Justice Douglas said he would have sent the cases of the other children back to lower courts to learn whether or not children wanted to attend school past 8th grade. Mr. Yoder's daughter testified in lower court that she wished to be educated at home.
Were there any similar court cases?
One similar court case is the Pierce versus Society of Sisters in 1925. Oregon had banned private school attendance in hopes of eliminating religious schools. Oregon required parents or guardians to send children to public school between the ages of 8 and 16. An order of nuns called the Society of Sisters cared for orphans and provided them Catholic schooling. They sued the state, arguing that the requirement to send kids to public school violated the First Amendment's protection of freedom of religion. The Supreme Court ruled that the Oregon law was unconstitutional under the Due Process Clause of the 14th Amendment, incorporating the right to religious liberty. As long as private school education adequately prepared students, the state couldn't prevent parents from sending their children to private schools.
The next similar court case was Price versus Massachusetts in 1944. Sarah Prince challenged Massachusetts child labor laws that prevented boys under the age of 12 and girls under the age of 18 from selling any publications or other merchandise in public places. Sarah Price was a member of the Jehovah's Witness and the guardian for her niece, Bethany Simmons, who was 9 years old. Betty distributed religious literature on the street and accepted donations. However, this was illegal because she was under the age of 18. The Supreme Court upheld the state law prohibiting the distribution of religious literature in a public place by a minor. The court's reasoning for this was that a state's generally applicable regulation to protect child welfare and child labor core override the parents' free exercise of religious if it posed a threat to the child's physical or mental health or to the public.
And here are some relevant photos to the case. Thank you for watching. Hopefully you learned something about the Wisconsin versus Yoder case.